All right. Good afternoon, everyone. We will convene the meeting of the Gun Violence Prevention Working Group of the Bi Partisan Task Force on Gun Violence Prevention and Children's Safety. Welcome this afternoon. Representative Minor and I want to thank everyone on the working group for their diligent efforts over the past several weeks to put together the two lists that we will be presenting here today for advancement for leadership discussions in anticipation of an emergency certified bill that we hope will be forthcoming. After all of our discussions, as I said, after opening remarks of my co-chair, then we'll just itemize the lists, the items on the list, so that people will get an overview of what we're presenting here today. Mr. Co-chair.
Thank you, Mr. Chairman. I can tell you personally, I've probably received about 3,500 emails, and I don't know how many letters and phone calls, and this has been for me, quite an experience. The amount of outreach that people have done from the public has been, to me personally, very helpful in trying to reach a consensus. I think we do have broad consensus on many things. When you look through both lists, I think you're going to find that we feel, in a similar way, very passionate about some of the things that we believe will improve safety in the state of Connecticut and still allow people to own guns. So thank you, Mr. Co-Chair.
Thank you, Representative Minor. Any opening comments from members of the working group before we proceed to itemize the content of the list to be presented here today? Okay. Well, let me just begin. One list has been circulated, which is the list that represents the consensus ideas of the Democratic members of the working group. It is several pages long. I'll briefly summarize them. We'll see that the items of highest priority appear on the first couple of pages, but we believe that all of them are substantially good ideas that are worth advancing in this process. The first is to expand the definition of assault weapon by amending the physical characteristics that are scrutinized, in part by adding forward grips and barrel shrouds and requiring that a firearm have only one of the listed characteristics as opposed to the two required currently in order for it to be classified as an assault weapon. And that is the key definitional component. And then as of January 1st, 2014, to allow assault weapons that were legally possessed as of the effective date to continue to be possessed, but require owners to have applied for and received a certificate of possession from DESP. Therefore, the possession of any assault weapon without the certificate of possession would be a Class C felony with a 2-year mandatory minimum sentence from that point on. And the current penalty for such possession of an unregistered assault weapon is a Class D felony with a 1-year mandatory minimum. We would maintain the existing exemptions for members or employees of local police departments, DESP, the Department of Correction, military or naval forces of Connecticut or the United States for use in the discharge of their official duties. Second, banning large capacity magazines, which would be defined as those that accept more than 10 rounds of ammunition. And effective October 1st, 2013, ban the possession of such large capacity magazines and like devices and provide a process for their disposal. Third, require a permit to purchase a rifle or a shotgun. And this permit would be available to individuals aged 18 and older, as opposed to 21 and older for a pistol or revolver permit. And it would have the same application criteria and process as that for the current eligibility certificate for a pistol or revolver under Section 29-36F. But if an individual has a permit to carry a pistol or revolver, that individual would be able to purchase a rifle or shotgun without getting the new rifle or shotgun permit. Holders of a rifle or shotgun permit, on the other hand, would not be able to buy a pistol or revolver under their existing permit, would still have to get one for that. Next, require a universal background check and DESP approval for every sale and transfer of a firearm, including the private sale or transfer of a rifle or shotgun. So this is Currently, private sales or transfers of rifles and shotguns require no background check whatsoever, and conversely, sales or transfers of rifles and shotguns from dealers and all sales or transfers of pistols and revolvers do require a background check to be performed by DESP and DESP approval before the sale is finalized. So the detailed DESP approval process applies for each sale or transfer of a pistol or revolver, even though the buyer or transferee also is required by law to have a valid permit or eligibility certificate. Thus, this proposal would require all private sales or transfers of rifles and shotguns, including those sales and transfers made at gun shows, to go through the same DESP background check and approval process as all other firearm sales or transfers currently do. Next, require for the purchase of any ammunition presentation of either a permit to carry a pistol or revolver or the new rifle or shotgun permit. This would take effect after the new rifle or shotgun permit becomes available, and that addresses a significant gap in our current law where now there are virtually no controls on the purchase of ammunition, even by people who are legally barred from having possession of a firearm. Next, establish a statewide deadly weapon offender registry, and this is something of significant importance to urban legislators. The recommendation of a number of urban police chiefs on the grounds that having a registry of this kind will help police to identify suspects when new acts of violence occur in their communities. It would require individuals convicted of certain firearms offenses and other offenses involving the use or threatened use of a deadly weapon to register with DESP for a period of 5 years after their release into the community, and require registrants to check in with the local authorities where they currently reside once each year for their registration period. And the registry would not be public, would only be accessible to law enforcement personnel. This would also have the effect of putting some oversight on some of the released prisoners who are identified as often having the highest rates of recidivism, and that is the so-called end-of-sentence releasees, who are people who do not get any benefit for any early release credits, or not released into a halfway house, but serve their maximum time in prison, often having not been cooperative during their time as prisoners, but come back into the community with no further leverage or control on them. These are often the people who wind up in homeless shelters in our central cities, have a high rate of recidivism, and this would particularly affect that category of offenders who are under no other control, but under this proposal would be required to report into their local police department for a period of 5 years. Next, we have a number of provisions strengthening laws regarding firearms trafficking and straw purchases. Our research indicates that a significant majority of Connecticut gun crimes are perpetrated with firearms that were originally legally purchased in Connecticut. And according to the Bureau of Alcohol, Tobacco, and Firearms, in 2011, 65% of Connecticut crime guns that were traced had been originally legally purchased in the state. In 2006, 67% of such traced crime guns originated here legally. So it seems very clear that firearms trafficking and straw purchases are extremely serious issues in our state, and the following list of proposals are designed to strengthen our laws in order to decrease the amount of handguns flowing into our neighborhoods and more severely punish the illegal possession of firearms, the transfer of firearms to those who cannot legally possess them, and firearm traffickers, straw purchasers, and their clientele. So we have a list of those offenses. We also would seek to prohibit individuals from purchasing more than one pistol or revolver within a 30-day period to cut down the potential flow of such weapons. And then expand the scope of and strengthen penalties under 53202 AA for firearms trafficking, including imposing a mandatory minimum fine of $10,000. So under this provision, it would, as you can see, that we have a list of current penalties that are generally increased. So, for instance, increasing the penalty under 53A212 for stealing a firearm up to a Class C felony from the current Class D felony, with a 2-year mandatory minimum sentence and a $5,000 mandatory minimum fine. And by what we mean by mandatory minimum fine, one that cannot be reduced or remitted unless the court affirmatively states on the record its reasons therefor. So a judge would have to make a specific finding on the record of a reason to not impose that mandatory minimum fine. Obviously, we know in some cases if people truly are indigent, they don't have the capacity to pay a fine of that kind. But on the other hand, many firearms traffickers are people of significant means, although those means may have been gained illegally. Again, amending 29-33 to increase the penalty on both the transferor and the transferee for any sale or transfer of a pistol or revolver in violation of its provisions to a Class C felony up from a current Class D felony. So we see many of these are provisions where a penalty is being upgraded. For instance, the bottom of that page 3, we amend 29-32 to increase the penalty for failure to surrender a permit to carry a pistol or revolver within 5 days after it's been revoked to a Class A misdemeanor up from a current Class C misdemeanor. So the pattern on most of these is an upgrade in the designation of the crime, in many cases from Class D to Class C felonies, or in some cases from a misdemeanor to a felony. For instance, 29-361I increased the penalty for failure to surrender an eligibility certificate within 5 days to a Class A misdemeanor. So we have a number. The pattern of these statutes are the penalty statutes, where in many cases we are increasing the penalties, we said, from Class D to Class C felonies, or from a lower grade misdemeanor to a higher grade misdemeanor. Then moving on to page 5, we seek to clarify the standards for the determination of a permit applicant's suitability to carry a pistol or revolver. This is also an issue that was brought to us by the Police Chiefs Association, indicating that there has been substantial areas of disagreement between police chiefs and the Board of Firearms permit examiners about what is or is not appropriate under a suitability review that local police are required to carry out regarding permit applicants. And the concern is that some of the issues that police believe are in fact necessary to consider under a suitability review have been deemed not to be so by the firearm permit examiners in overturning denials of permits or revocations by police chiefs. So this provision would amend Section 29-29 to give issuing authorities up to 12 weeks to render a decision. Currently, 8 weeks is the law, and also establish that in determining suitability, the issuing authority may consider factors including but not limited to psychiatric disabilities, acts deemed to be attempted suicide or other harm to self, participation or alleged participation in the commission of any crime involving the violence or use of any firearm, arrests or convictions or other involvement in the use or distribution of any controlled substance, criminal convictions and criminal arrests, association with persons not eligible to obtain a pistol or revolver permit, military service record, incidents of workplace violence, incidents of domestic violence, prior protective or restraining orders, or foreign orders of protection that have been issued against the applicant, allegations of or conviction for cruelty to animals, and any other factors the issuing authority reasonably believes contribute to the applicant's suitability to possess a firearm. So we believe that the clarity of that definition will help resolve some of the outstanding issues about what is or is not appropriate under a suitability review. Next, we would specify that individuals prohibited from possessing or purchasing firearms are also prohibited from possessing or purchasing ammunition. And then expanding the firearm safe storage requirements. This is one of substantial interest and broad-based interest, which would amend the current section that provides that the current requirement to securely store a firearm applies. The new provision would be not only when a person under 16 years of age is likely to gain access to the firearm, and that's our current law, that basically safe storage applies in households where there are minors under the age of 16, but we would expand that to also include when any resident of the premises where the firearm is stored is ineligible under state or federal law to possess such firearm himself or receive a permit to carry such firearm. So again, any household where there is someone who has a legal disability because of a prior criminal conviction or restraining order or mental health issue, the owner of that weapon and the person who legally has possession would also have the burden of safe storage. Or 2, when the owner of such firearm knows or should know that a resident of the premises poses a threat of harm or danger to themselves or others. I believe that was based on included in a proposed bill by Senator France earlier in the session as well. Next, limit firearm permit applications to 1 year in town of residence. Currently, an applicant for a pistol or revolver permit can apply in both the town where they live and the town where they're employed. This is a problem. The police chiefs pointed out to us that sometimes an applicant who may be turned down in his town of residence because of suitability issues there, rather than appealing that denial, may just file an application based upon the town where he works and may not be as well known in the community. So this would limit it to town of residence, and that we believe that is a potential abuse under current law. Next, increase the involuntary commitment look-back period from 12 months to 5 years. Currently, an individual may not possess either a firearm or a permit if he or she has been confined in a hospital for persons with psychiatric disabilities by order of the probate court at any time in the prior 12 months. This proposal would increase that look-back period for such involuntary commitments to any time within the past 60 months, so 5 years instead of 1 year. Next, we believe that with the expanded permitting and oversight that is being recommended, that some fee increase for permits to carry a pistol or revolver will be necessary. Next, requiring permits for gun shows. Currently, gun shows are not required to be permitted by local police. This proposal would require gun show promoters to obtain a permit from the local chief or chief elected official before holding a gun show. Because of the concerns that the police and others have had with the Board of Firearm Permit Examiners, we're putting on the table a proposal to either eliminate or reconstitute the Board of Firearm Permit Examiners. Reconstitution might also include either adding additional members or deleting some of the slots that are currently provided for. We believe this certainly deserves further study by leadership in preparing an ultimate bill. Next, banning the sale of all armor-piercing bullets. We do currently have a law banning armor-piercing bullets, but only 50 caliber bullets of that kind. So this proposal would ban the sale or transfer of bullets that are specifically designed to be armor-piercing, regardless of caliber. And then eliminate the future issuance of eligibility certificates for pistols or revolvers. It appears there are only 57 of these certificates currently issued in the state. This proposal would grandfather these existing eligibility certificates, but stop the further issuance of any new ones, and instead subject them to the new permit process. Next, repeal the hunting license exemption for the 2-week waiting period for long gun purchases. Currently under 29-37A, a purchaser of a long gun must wait 2 weeks before delivery of the firearm, and there are 4 exceptions to the waiting period. First, if the buyer has a pistol permit or eligibility certificate. Second, if the buyer is an active member of forces. Third, if the firearm is an antique. Or fourth, if the buyer has a valid Connecticut hunting license. However, there's no background check required to get a hunting license, as those are issued through town clerks rather than through the more rigorous permitting process through the state or police departments. And this proposal would eliminate this exemption to the 2-week waiting period effective upon passage. Next would be prohibit the sale by dealers of handguns other than personalized handguns after they become commercially available. As we've seen both in our public hearing of the working group and others, that there are proposals that ultimately guns could be made safer as modern technology is developed to personalize weapons to allow them only to be successfully fired by a person who has his or her ID involved in the operation of the pistol. We're told that that technology is not yet universally available, but it would require the Attorney General to determine when personalized pistols or revolvers are available for retail purchase, and within a specified time thereafter it would be unlawful for any licensed firearm dealer to sell, expose for sale, possess with intent to sell. This is based upon a New Jersey statute that was passed a couple of years ago that has this provision. In other words, saying that recognizing that the technology does not exist yet, for broad-based applicability, but believing that this would be a substantial improvement in public safety, to give the Attorney General the authority to determine at what point a commercially viable option of this kind would exist. in our state. Next, and prohibit the carrying of firearms into licensed daycare facilities would contain a modified exemption for individuals who reside in family daycare homes, it would provide that during business hours, any firearm on site that belongs to a resident of the home would have to be both unloaded and locked away in a secure chamber. The exempt members are employees of local police departments or DEST for use in the discharge of their duties. And finally, prohibit carrying of firearms into a private residence of another or house of worship without permission. This again would also exempt members or employees of local police departments or DEST for use in the discharge of their official duties. So I will yield at this point to Representative Meyer for the presentation of his list, and I believe we'll certainly see that there is a significant degree of overlap.
Thank you, Senator. Included in our list of recommendations is to require background checks for the purchase of any firearm in the state of Connecticut. Currently, that's not required for private sales. We believe that the time has come to change that, to include private sales. I would like to point out that even though in the state of Connecticut you can buy a gun with a hunting license, you don't get out from underneath the background check when you walk into a retail outlet anyway. So the hunting license, as far as we're concerned, is not the issue. Eligibility certificate is our next point, including fingerprints and completion of a firearms safety course. One of the things that we heard from a lot of people was that gun safety and training might be helpful to many, could be helpful to all. And so we are suggesting that we move towards a similar eligibility certificate to the one that we have currently under law in Connecticut for a handgun, and that would be required to purchase any long gun, either at retail from a retail establishment or a private sale. The eligibility certificate must have a photograph, which is similar to a handgun permit, and you must pass a national criminal background check after being fingerprinted. I would draw to the group's attention that under our current law and under federal law, the NICS system, which is the background check, does not actually check fingerprints. And so if I went in to buy a gun and didn't have an eligibility certificate, it's a name recognition process across the country, checking a whole bunch of different databases, but it's my name. And so we think going to an eligibility certificate would be an added step on making sure that people without mental health problems that have been determined by the federal government or by our state laws should be significant indicators that someone shouldn't own a gun or a criminal background. Increasing the age to 21 for certain long guns. There has been a lot of discussion in the state of Connecticut over long guns with a magazine capacity of 10 rounds or more. They come in all sorts of different styles and colors. We believe to go down the road of trying to add to or subtract from some designation that at one time include a bayonet mount or a flash suppressor is only going to bring us back here again. What we do concede and would agree is that there's a lot of similarity when you get to large magazines between handguns, which many of them have over 10 rounds, and these long guns which have capacity well beyond 10 rounds. And so our recommendation is to change the age from 18 to 21 and track the gun through the sale process in the secondary market. So currently, if I wanted to sell my gun to Senator Whitco's, that is not required in a long gun. For purposes of these long guns, we want to see those secondary transfers occur from person to person to person for the gun's life. We're going to increase, we suggest that we increase the requirements to purchase ammunition and magazines. I've heard from Senator Looney, I've heard from Representative Walker, that more so probably in the case of urban centers, the availability of ammunition to people who do not lawfully own a gun is a problem. And we've done a good job in the state of Connecticut in trying to reduce the amount of illegal firearms by taking a step and requiring an eligibility certificate to purchase ammunition. And we believe that we should have that same requirement for magazines, that you would limit the ability for people who cannot lawfully own a gun from lawfully buying ammunition. I was kind of amazed to know that magazines aren't controlled in any way. And so we have all this discussion about banning things, but we don't even restrict, as we do ammunition now, the purchase of magazines. So we would add that to the list as well. Persons prohibited from owning a firearm would be therefore prohibited from buying ammunition or magazines. Safeguards to purchase of both guns and ammunition to the Internet. We believe that those purchases should still be allowed over the Internet, but we're suggesting that there is the ability through an eligibility number or some certificate number so that the retailer would know if you place an order somewhere outside the state of Connecticut that you are a lawful gun owner and able under our Connecticut statutes to buy ammunition, magazines, long guns, and the like. We do believe, after a lot of communication, some testimony, that the Firearms Examiners Board that has existed in the state of Connecticut for some time could benefit from the addition of an individual that has a mental health professional background. We've heard a lot of conversation, I think, here in Connecticut over the last 2 or 3 months about mental health status. How did someone get a gun? Why didn't we know? We don't have anyone on that board that, in my view, and I think in the view of the Republicans at least, that would be able to logically determine who should and who shouldn't have access to a firearm. So we think that's a good addition. We believe there are 2 public members currently. One of them could be changed out for this individual. We also agree that stricter mental health lookbacks are paramount in this conversation, going from 1 to 5 years. We also call out voluntary commitments of at least 30 days, and emergency certification admissions of 15 days should be statistics that we should be paying attention to here in Connecticut. We don't believe they hit the federal database. I think we've had a lot of conversation here about the NICS system. I've become personally aware that the NICS system has plenty of holes in it. This morning, I think I heard at the DESPP that they believe about 18 states actually submit information to this national registry. While I think we can take some steps here in the state of Connecticut, it seems to me high time at the federal government. They ought to be taking some steps to try and shore that database that people keep talking about. Safe storage of firearms and ammunition. I think our recommendation is very similar, if not the same, to the Democrats, in that we believe that just limiting this to households that have individuals living there 16 years of age or younger in terms of the lock safe storage requirement is not going far enough. While we don't have any specific detail on the mass shooting that occurred in December, I think we all know that there are circumstances under which people who probably shouldn't have access to guns are gaining access to guns, and they're owned by people who own the gun lawfully. And so our suggestions are that those guns be kept in a locked box or secure container. It would not be enough to have a cable lock put through the receiver. Prohibition of applications for permits to carry a pistol from any jurisdiction other than the applicant's residence. We heard from chiefs of police during the public testimony and then during the informational hearing that when they check Craig Miner's database, it doesn't come up at his place of business, it comes up at his place of domicile. And so our recommendation is that that is where the application should be made. We don't believe under the early release program anyone should be eligible for early release if you commit a crime with a gun. And so our recommendation includes a prohibition from those individuals receiving earned risk reduction credits. We believe that a statewide deadly weapon offender registry would be helpful. We did hear and have heard from police personnel that they would like to see the picture of somebody when they pull the car over and know what they've been convicted for in the past. Sometimes it comes up as a number, and they're not sure who it is. And so being able to readily identify someone is important. As Senator Looney stated, that being on that registry would also carry with it an obligation to check back in. There are a series of requirements in our proposal. Gun shows. We're recommending that gun show approvals be done through either the local chief of police or local chief elected official. There are 169 municipalities in the state of Connecticut. They all handle this sort of thing differently. My argument to some has been, we don't even allow in the town of Litchfield you to set up a hot dog wagon without having somebody's permission. My understanding today in the state of Connecticut, you'd go through the Department of Public Safety. I think that this is a reasonable change. Ban and sale of armor-piercing and incendiary bullets. As Senator said, we currently ban under the 50-round category of caliber, armor piercing and incendiary, and so we would like to see that carried down to smaller caliber cartridges. Reconstitution of the statewide firearms trafficking task force. That's a program that existed here for many years. I know it's the subject of some legislation currently before the legislature. I think we'll probably have a public hearing on the Appropriations Committee. And we're also recommending that it be funded at a level of $1 million. There are a list of penalties, increased penalties of firearms trafficking and straw purchasing that I can go down individually. They go from Class B, Class C to Class B, Class D to Class C. In every one of these cases, they are associated with the transfer, knowing transfer of a gun to someone that knowingly couldn't possess a gun on their own, or buying it for them, and so on. And so there are about 1, 2, 3, 4, 5, 6, 7, 8, 9, 10. I believe there are 11 penalties for which we would recommend increasing either jail time, fines, or both. And that's it.
Good.
I've had a lot of fun with you, Senator.
Absolutely. I wanted to thank Representative Minor for all of his extraordinary work and leadership on this this working group, and his thoughtfulness throughout, and willingness to engage in great detail on all of these provisions and discussions, and also thank all of the members of the working group for their interest, and also for their contributions, as well as for their commitment to attend the lengthy public hearings. Most of the members, of course, we had that 17-hour public hearing on January 28th that started at 10 o'clock on that Monday morning and ended at 3 o'clock the following Tuesday morning. And then, of course, we had the joint hearing in Newtown that Wednesday, the 30th, where all of the members of the task force participated. And then the following week, we had the follow-up presentations with gun manufacturers, with the state police and municipal police and municipal officials following up. And then, of course, the other working groups had significant public hearings as well. So a great deal of time and effort has been put into this process as we move forward to the next level of advancing a range of options to leadership for preparation of the final bill. So at this point, any comments from other members?
Let me just say, echo your comments of thanks. Both Republicans and Democrats have been very helpful to me over the last couple of months as we've looked at gun safety and a number of other issues. These are recommendations, not all of which we are unified on. Senator Looney and I have worked for a number of weeks now to try and come to some consensus on a number of issues. I think if you compare these two lists, you will find that there is broad support for a number of the initiatives. There may be some differences in how we achieve them. There may be some differences in who we should suggest shall do them. But that's one of the reasons why when we kind of came to our final resting place here, I think I know that I thought it was the best opportunity for us to move this to the next level so that professionals could begin to take a look at some of these recommendations. We may agree that expanding a background check has great value to this process. We have no idea how we'll do that. We may agree that an eligibility certificate may be the right way to go into the future. We don't know who will do that. And so, you know, one of the problems I think that we face in this process is, while we all came together initially under the guise of reaching for some solutions that made sense, I think at that point we weren't sure, even if we reached those, how we were going to accomplish them. And so many of these require the legislature to do something other than just cast a vote. So I think timelines, as Senator Looney and I have talked about, will be key to an orderly transition from where we are today. We are New Englanders. Change doesn't come easy, but I think many of us believe that in the area of safety, safe storage, and a number of other things, change is here. So thank you again, and if there are any comments, I'd love to hear them.
I just have a question regarding process. When we were originally charged, it was my understanding that each individual subgroup was going to try to form a consensus set of recommendations to then go to the next level, the legislative leadership. I see two lists here. I see some overlap, but I definitely see some distinctions, and I'm wondering if we're going to go through these and find out where there's commonality and vote on that, and where there's no commonality and vote on that. And I say that because I'm a little concerned that if we just, and maybe I'm way off on this, but if it's just a process of passing along two lists, then we're not speaking with any voice here, and how would the leadership know where there's commonality or not commonality? And also, when we do discuss each one of these individual proposals, we may be able to refine them in a way, and how nice. I think if this group could find, maybe not 100%, but if 90%, we'd iron it out, and it's almost 100% vote from this committee, so that we draw very clear lines where there's sharp differences between, and I won't even say necessarily Republicans and Democrats, but just some folks that take one position and some folks that take another, because quite frankly, over my years on judiciary and handling some of these issues before that committee, many of these debates are along geographic lines as well as partisan lines. And so I'm just wondering, where do we go from here? Because I don't think that we will have fulfilled our mission if we just pass along two lists.
Thank you, Senator Kissel. I disagree. I think we have met the charge of what we need to do. We have worked to prepare these two lists. It's quite clear that there is consensus on some items and not on others. This is not a committee of the General Assembly that's required to report out bills for action, but a set of recommendations to be further vetted in the leadership discussions that will follow. Obviously, the way the task force was set up was somewhat of an ad hoc basis, and the understanding is that we will now have a list of options to present rather than a set of proposals to be voted up or down. It's quite clear that there is some significant overlap on these lists. It's also quite clear that there are some differences, namely about the issue of assault weapons per se and about the handling of large capacity magazines. Other than that, there are many consensus issues of overlap regarding screenings, permittings, perhaps. As Representative Minor said, there are also some issues left open, which is where there may be a need for expanded permits or fees for those permits. Exactly what level those fees will be set at remains to be determined, as well as committing to particular expenditures for various proposals that would be required and potentially having a budget impact here.
Well, if I may, Mr. Chairman, and I respect the opinions of the two co-chairs. It would be remiss of me if I didn't state that I have strong concerns regarding the first two proposals from my colleagues on the other side. I don't know what kind of message we send when we're exempting manufacturers from creating magazines and guns, and yet forbidding the proposals to forbid Connecticut residents from owning them. I don't know how that message meshes up. Technically, if as part of the recommendation we are making illegal the offering for sale of certain firearms and magazines, and at the same time carving out an exemption for all manufacturers. And I also have strong concerns regarding the magazine proposal, in that eventually those things have to be turned over to the state, and it does not appear that there's any mechanism for compensation. And to me, that would be an unconstitutional taking of private property that has otherwise been legally obtained by the citizens of the state of Connecticut. So I have strong misgivings even with the technical nature of those proposals, and I just wanted that as part of the record. Thank you, Mr. Chair.
And thank you. And I just, from my perspective, when I signed on to this job, I thought that we would reach some consensus, and that those would be the ideas that would go forward. Like everything else in life, this has been a lesson and kind of a learning experience to me, that many of these issues I don't think are resolvable in 2 months' time. It may seem simple to someone to make a recommendation to do something, but as you point out, Senator, there are ramifications to many of these. And even in the areas where we concur, I still think taking it to the next level provides leadership with the opportunity to make the decision of what will become part of what I think is the most important message, which will be this what I would hope would be very significantly unified voice on behalf of what our charge was and the Mental Health Committee was and the School Safety Committee was. It may not be all of this. It may not be half of this. There's a committee process. I'm looking at Chairman Foxit here. There are committee processes that will play themselves out over the next couple of months, 3 months. I don't even know how many months. But some of these items have never even had the benefit of a public hearing. They came to us through this process of deliberation. And so many people have reached out to me and said, when are we going to have an opportunity to comment on some of these things? And I would hope that the leadership, as they look at this list, might be able to separate those items which might seem to be brandy spanking new to somebody from those that seem to be in that list of ideas that we spoke about for many, many hours. So one of the things that I'm hopeful that the leadership will deliberate about is how the public will be heard between now and the date of what I think is the 13th. No one's confirmed that yet, but I do believe there's been a lot of discussion about that being the date of the next step. So thank you.
Thank you, Mr. Chair. I believe that I think both Senator Williams and Speaker Sharkey have an interest in finding some way to have additional public process once there is an agreed-upon content for proposed e-cert bill to schedule a hearing. Whether it is more likely, I think the concept would be an informational hearing with expert speakers in different categories of issues addressed under the proposed bill. But I think the understanding is that there would not be a vote without some formal opportunity for further input and comment by the public through a hearing process on the e-cert bill before it is submitted to the membership for a vote.
Can I just make one point? My colleague to the left here is saying that perhaps we need to be clear about who the leadership is. When this larger task force was formed, the heads of each of the chambers, all of the parties, and majority leader in both chambers were added to that. So there are 6 leaders that will, in my view, take a look at all the recommendations from each of the subcommittees. That's, when I speak about leadership, Senator, I think that's what you are determining as leadership as well, right?
That's certainly right. The 6 leaders will convene from this point on, but of course, ultimately, Speaker Sharkey and Senator Williams are the 2 who have to sign the e-cert bill in the end. So all 6 of us will have, I think, vigorous discussions from this point on. But obviously, the Speaker and the President have to be the ones who agree upon final content.
Representative Dargan.
Thank you to the chairs. Before we came in here, Senator Hartley, myself, and the ranking members of Public Safety, Representative Giggler and Senator Guglielmo met on bills that are before us dealing with gun issues that we will in the future have a public hearing. And Senator Hartley had a suggestion to cross-reference the 2 lists. And we were amazed that there's like 16 items that there is some agreement upon. So to that extent, there is movement in the right direction of this subcommittee, whether that be in penalties or fines or other areas. So I believe that we do have a good policy in place. I know that 2 committees of cognizance will have further hearings as we progress. That's Committee of Judiciary and the Committee of Public Safety and Security on gun-related issues. But we were somewhat overwhelmed that looking at the list, we didn't think we could come to any agreement. But there are 16 items that are cross-referenced from these 2 proposals that there's some sort of agreement upon. So I'm impressed with that.
Representative Carter.
Thank you, Mr. Chairman. As we've moved through this process over the last few months, there's been a great deal of attention paid to the fact that this is a bipartisan process. And echoing the comments that were made just a moment ago by Representative Dargan, there has been a lot of forward progress made on things that we all, from both sides of the aisle, see as important steps to take to prevent gun violence. Remember, this was a bipartisan task force. So as we move forward from this day, I want to urge one thing. I hope that our leadership on both sides of the aisle and all the caucuses take the time to think of a task force recommendation. And that's important because as a group, we've come together bipartisanly to think about the things that we do agree on. I would personally like to see the task force recommend something. I do not want this to be something where we have just been a rubber stamp for the ability to just, pass legislation or get it through what we thought was a public hearing process. The task force should come together, the leadership should come together and recognize in all parts of these subcommittees or these working groups where we've worked together to find good ideas and put that out in some sort of recommendation. Then we can move forward, and things where we don't agree, just as Representative Dargan said, we can go through the committee process because we have some time to do that. But I think it's important to give credibility to what we've done for the past 3 months, that we take some time and have a task force recommendation. Thank you.
Thank you, Representative. Senator Hartley?
Thank you, Mr. Chair, and to both of our chairs. I just want to recognize the incredible amount of work that's gone on. I think we have accomplished much, but I do believe there are many miles left to go. It is basically uncharted waters in terms of how we have proceeded and will go forward. So my question is, we are one entity, and I think that was pointed out, but we recently have had policy proposals put out by the governor, and in addition to that, there is also another gubernatorial task force which is also deliberating. I'm wondering how that folds into our task force work and ultimate recommendations.
Good luck with that.
Thank you. Well, Senator Hartley, as you know, some of the governor's proposals there is a significant amount of overlap with some of the ones on the list here, particularly on the Democratic list, although not necessarily identical. But obviously that becomes an issue for the next stage of the sifting that will go on in the leadership discussions, and then ultimately for the preparation of a finally cert bill. We believe that there will be other recommendations that may come forward at a later date from the governor's own commission that has a date of March 15th to finish up its work. We think that it's likely, since given the makeup of that commission, apart from issues related to gun violence prevention, which was our charge here, since there were so many mental health professionals and others on the governor's commission, we think that they may be coming out with some more recommendations to supplement the work of the mental health working group on our own legislative task force. So we expect that there will be additional ways for recommendations to get into the process. But at this stage, the governor's proposals, as people can see from the recommended list here, there is some overlap with what he has proposed.
Okay.
Good.
Representative Rubimbis.
Thank you, Mr. Chair. I guess for the record, I simply want to also state my strong concerns regarding the two lists that we're putting forward, especially in light of the fact that, at least for myself, either for lack of clarity and/or changing rules in the middle of the road, it was my understanding that this task force was going to have a unified recommendation. What I feel by putting this forward at this time, and with the responses to a lot of the very good questions that have been raised, especially the last question by Senator Hartley, as to how the other task force that's been appointed by the governor, as well as now the governor's position regarding his proposals, may impact this. We, as members of this task force, may have strong feelings and positions as a result of our constituency or our personal beliefs that some of the stuff that's being proposed right now is not anything we would want to support, yet it's certainly something that later on could be used in whether it's a negotiation process or not, at which time that may lead many of us not being able to support something that we otherwise wanted to as a unified task force to put something forward that we can all support. Certainly there's always going to be differences of opinions, differences of proposals, and that's why we have committees of cognizance, whether it's the Public Safety Committee or the Judiciary Committee, to go through the process that's been set up for those and to have public hearings and to hear from the public. I still haven't heard a firm commitment that even what's going to come forward as the proposed recommendation of the entire task force and its subcommittees are going to have a public hearing, and I have strong concerns that with a March 13th deadline that may not even be the case. On top of all the other concerns that have been raised even in our working group of not even having a full investigation done, I absolutely agree and support that we do have people of expertise in these areas that need to vet our recommendations, but I think a good effort should have been made by this working group to put something forward that we all supported.
Nothing else? One more. Senator Wickhouse.
Thank you, Representative Minor. I just want to offer my thanks to not only the chairs but the members of the committee. And I think it's been an educational process that we've all learned, not only in this new process that we're going through, but also on the content of what we were discussing. And I think one of the things that I gleaned the most, it wasn't even from this working group, was from the governor's task force that he put together, where he had the experts come in from that were a part of a panel in Columbine and Virginia Tech, where they said, do not rush this process. That's the best advice that they could give. And I would hope that we're not rushing to reach a date on the calendar to have a vote in the legislature without giving a full opportunity for debate amongst the legislative leaders, having a product that is drafted, available to the membership to read, and also for the public to read, because they're so divided out there in the public on both sides. And prior to this, they were talking about concepts, but now they'll actually have specific language to look at to see what the legislature is trying to do. And I think what we're trying to do is to create good public policy to make our citizens safe while making sure that they have the rights that are given to them under the Constitution. So I think that's a delicate balancing act, and I would hope that we don't rush to a date on the calendar just to say we got it done. So I would hope that the leaders take that into consideration during your discussions. Thank you.
Thank you, Senator.
Thank you. The working group has now completed its work. Wanted to again thank everyone for their hard work and conscientious participation in this entire process. As we said, the list will be forwarded to the next level. And again, thank everyone so much for their willingness to participate and the degree of hard work and good faith that everyone showed in the process. Thank you all very much.